back first. Okay, for lunch. Anybody indulge in those 4-layer cakes? I know they have there. Okay. Right. Afternoon, so we expect to stay awake for sure. All right, as we talked about before, the defense is under no obligation on to testify, but this one will ask if the defense is offering you for, will the defense be offering you for?
Yes, Your Honor.
Okay, quite first witness.
The defense calls Gary Kilpatrick.
Solemnly swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. Stop what you're doing.
State your name for the record, please.
Gary Evans Kilpatrick,
Mr. Kilpatrick, where do you live?
3397 Cherry Brook Drive in Jamestown, North Carolina.
And how are you employed?
I founded and owned the Kilpatrick Group back in 2002.
And what kind of group is that?
It's just a professional corporation.
Okay. Are you in your group? Are you an engineer?
Yes.
Okay. Please tell us about your education and training.
I'd like to go back a little bit and talk about my experience before I went to college. I worked in the industry for 8 years, most of it in the automotive industry. I had a chance to work for Rugged Equipment, so the forklift, the front end loader, the Bobcat, that's their product. And I was a machinist and assembly technician for 5 years. And then I started taking night classes at a Mitchell Community College in my hometown. And I got an associate in applied science degree, college transfer, and transferred it to NC State and studied mechanical design engineering from that point on. I graduated in 1990 with a Bachelor of Science degree in mechanical design engineering, first a little bit in automotive.
And so are you an engineer?
Yes.
Yes. Are you licensed?
Yes.
What states?
For North Carolina, I took the exams in North Carolina, but I'm licensed from Maryland, I think from New York, all the way down to Florida, Tennessee, Wisconsin, Louisiana, Mississippi, Alabama. So
What is your practical experience?
practical experience.
Yes.
In regards to what?
To your vocation.
Okay. I'm a crash reconstruction engineer, and I apply the sciences of engineering dynamics, static dynamics, dynamics of machines to use the equations in those courses at college, along with my education at Northwestern University Center for Public Safety to reconstruct traffic crashes.
And over the years, have you taken a variety of classes in this field?
Yes,
Have you published articles?
I've got 2 right now.
Have you previously testified as an accident reconstructionist in the court of law?
Yes,
Have you previously given depositions in your field?
yes,
How many depositions?
36 so far,
And how many trials?
4.
Four.
And this will be the 5th.
Are you able to apply your qualifications to assist the jury in this case?
Yes,
May I approach, Your Honor? You recognize this document?
yes, that's my CV.
May I introduce you? Sir, 83 next. 083. 083? Yes, sir. Your Honor, at this time, in light of his history, Mr. Kilpatrick's background, experience, and qualification, I would tender him as an expert in the field of accident reconstruction.
State I need to.
Your Honor, state would like to be board our Mr. Kilpatrick.
May we approach, Your Honor?
Thank you, Your Honor.
Good afternoon, sir. My name is Jamie Polito. I represent the state in this matter.
Can you speak up? Sorry to hear you.
Yes, sir. Have you ever worked with law enforcement?
I'm thinking. I have interviewed police officers before in my line of work, and I don't think I've ever actually assisted a law enforcement officer in a reconstruction of an accident.
Okay. Have you ever worked with law enforcement in any capacity whatsoever as a member of law enforcement?
No.
Have you, is it fair to say then that you have not participated in any law enforcement trainings?
That's correct.
Okay. In reviewing your CV, and please correct me if I'm wrong, I did not see any listed trainings in toxicology, pharmacology, medicine, physiology, or impairment science. Is that correct, sir? You have not attended wet labs where you get to see how alcohol impacts individuals' reflexes, judgment, and reaction times. Is that correct, sir?
I read about it, but I've never had any formal training.
Okay. You have no training or experience in driving under the influence investigations or detection?
No.
Okay. You do not have training in drug or alcohol recognition or impairment science. Is that correct, sir?
Correct.
Have you ever not been qualified as an expert in a case where you have been offered as an expert?
No.
Okay. What percentage of your business is supporting litigation?
About 100% right now.
Okay. Are you familiar with Tennessee law regarding the right of way when a vehicle changes lanes? And I just, yes or no, not asking for you to quote the law.
I'm not familiar with Tennessee laws or not.
Okay. Fair to say you're not familiar with what the law says regarding the responsibility of the driver who seeks to change his lanes then. Is that correct, sir?
That's correct.
Okay. What percentage of your business is accident reconstruction involving motor vehicles driven on roadways, please?
I would estimate probably about 30%.
Okay. How?
What was that question again, General? What percent of businesses?
Yes, sir. Just to repeat for your honor, what percentage of his business is accident reconstruction involving motor vehicles driven on roadways, sir?
Oh, 30%.
How many accident reconstructions on motor vehicles driven on roadways do you personally conduct each year?
I would probably estimate probably one.
What percentage of your time is actually spent on accident reconstruction involving motor vehicles driven on roadways, sir?
Not right. Ask that again.
Okay, and I will slow down. What percentage of your time is actually spent on accident reconstruction involving motor vehicles driven on roadways?
Are you asking on a case-by-case basis or overall?
Just in a year, if you had to take a portion of your time dedicated to accident reconstruction, how much of that time would be spent actually on reconstruction versus the rest of your business, sir? Accident reconstruction.
I would say probably 30%.
Okay. And that's that one case?
Mm-hmm. So what?
And that would be that one case that you previously mentioned?
I don't understand the nature of the question.
I'm happy to, yes, sir. I'll step back a little bit. I believe, and please correct me if I'm wrong, you previously testified that you handle about one accident reconstruction motor vehicle case a year. Is that correct?
Right.
Okay. So in the year, how much of your time is dedicated to accident reconstruction involving motor vehicles?
How much time
Yes, sir.
as far as hours?
Yes, sir.
I can answer that.
Okay. Less than 30% though?
I'd say probably 30%.
Okay. And would that be dedicated to that one case?
Well, for the one case, it's going to be 100%, but in the realm of all the other cases I work on, it'd be 30%.
Thank you, sir. Have you issued formal opinions in each of those matters, or is some of that time spent purely as a consultant?
Sometimes it's a consultant. Sometimes the cases do not warrant enough evidence for me to offer an opinion, and I tell the client that the case goes away. And that's kind of how it goes.
What percentage of your reconstructions involving motor vehicles driven on roadways have involved vehicle to pedestrian crashes?
Right now, I can't remember. I just don't know. I worked on so many cases, there's no way I can answer that.
Less than 10?
I can't answer that question.
Less than 5? Can't answer that question.
No.
Okay.
I worked on roughly 300 cases in my career. There's no way I can remember everything.
Okay, but not quite what I asked you, sir, and respectfully. Vehicle to pedestrian, potentially less than 5 cases.
I'd say yes, that's probably true.
Thank you, sir. Have any of those cases involved multiple pedestrians?
Probably not.
Have any of those cases involved multiple vehicles and pedestrians?
I would say yes.
One?
No, maybe.
So to be clear, your business consists of about 30% motor vehicle driven on roadway reconstructions, and I don't have the math here, but a much smaller percentage of those road reconstructions are vehicle to pedestrian. Is that fair to say, sir? Thank you.
One thing I would like to point out is I do a lot of work with ATVs, and I do get involved in reconstruction with ATVs, which is essentially.
Okay, but ATVs are often driven off-road, correct?
That's correct.
Thank you, Your Honor.
All right, you object to Mr. Kilpatrick testifying as an expert in this case?
I do.
Just when you're objecting.
Your Honor, this case involves multiple vehicles and multiple pedestrians. Based off of the experience alone that Mr. Kilpatrick has regarding these sets of issues and instances, it sounds like he is not qualified to be able to assist the trier of fact substantially with the information that he has. It's the state is concerned. While he might have education, it's the experience, it's the hands-on knowledge, the ability to apply the facts to the situation and then adequately explain that to the jury, sir.
What are your thoughts on the fact that he has done accident reconstruction for the same principles that may not have the facts of the prior cases may not involve multiple pedestrians, any pedestrians even, but the testimony is about the impact between Dr. McGinty's car, Mr. Vega's car. It's like any of your lawyer questions hit that really talk about its lack of experience in toxicology, lack of experience on factual cases, very similar to this one, as far as his expertise being helpful in the impact between the two vehicles, crash distance.
Yes, sir. Should this be a different set of circumstances? The state would certainly understand the defense's position in presenting Mr. Kilpatrick, but we are looking at potentially 5 seconds here, sir. Looking at the airbag control module and within that 5 seconds between when the ultimate event occurs and then the airbag control module begins ticking down to that 5-second reverse mark, we have the accident and then almost immediate impact with those victims. This is all kit and caboodle, sir. This has to be analyzed as such. Were there no victims in this matter? Were this not a vehicle to pedestrian crash? The state would understand, but that is not what we have here. It's such a tight instance that the state submits to the court that Mr. Kilpatrick is not qualified to testify in this matter.
It seems like everything from this comes from the interaction between vintage truck in the victim's van. What happens during that, the victim or the defendant's attempts to get into the lane, and the trajectory, braking distance, skid mark, yaw marks, those things seem to that would be helpful to this jury. Even though the resting spot, unfortunately in this case dealt with highly populated pedestrian area, as far as like which vehicle transferred enough energy to send the other vehicle a certain way or vice versa. I'm just giving a ballpark example. But it seems like that would be helpful to determine that.
In Your Honor, I don't want to repeat. It's the state's opinion in this matter, and the state submits to the court that due to the tight time frame and the science relied upon in this matter, especially if you take into account steering input and how it's all part of the same instance that is analyzed on a 1/10 of a second basis, we cannot separate these instances, especially as before the court, Your Honor, we have a vehicular homicide, intoxication, proximate result, and then the fatalities. It is a single count, and the state is very concerned about dissecting bits and pieces of testimony because we do not believe that would actually give the jury an adequate understanding of the entire situations.
Okay. You want to add anything to that, Mr. Wilson?
Well, Judge, it sounds like he just doesn't want my engineer to testify. Yeah, my expert testified. We're not putting him on, we're not going to be any testimony from Gary Kilpatrick about intoxication. There's not going to be any testimony about pedestrian being involved in any kind of accident. That was the end result of this accident. As the court knows, and through a cross-examination, we have a driver of the Nissan truck who has admitted to hitting the gas and accelerating, not letting a car over. And that is our focus. That is what the purpose of Gary Kilpatrick is on the stand today. He is an engineer. He is qualified. He's trained. He's been doing this for close to 30 years, 23 years. Can I ask some questions of Mr. Kilpatrick? I don't need to. Thank you, Your Honor.
Want further blood here, which you certainly can.
No, Your
Honor. I do find that a large component of this case, maybe not all components, but certainly one single large component deals with what happened on the road, the accident reconstruction expert that the state called. Certainly a lot of this testimony is about vehicles, distances, measurements, formulas. It does seem like this witness, while he could not testify about the impact of intoxicants on someone's reaction time, it seems like his experience, education, and training does fall within the realm of a component. Again, not all components, but at least one component that's very significant in this case. I think that his specialized knowledge could substantially help the trier of fact, and you can cross-examine the witness about all those points, about the limits of his expertise in front of juries.
Thank you, sir.
The witness be recognized as an expert in the field of accident reconstruction, and I'll do that in front of jury.
Thank you, Your Honor.
Read through that.
Yes, Judge. Your Honor.
Kilpatrick, have you been in the courtroom for the last 2 days?
Yes,
Have you been observing the testimony?
yes,
Have you previously been provided with data and information related to the accident that happened on November the 25th and 23 on Frazier Avenue?
yes,
And have you looked over all of that evidence?
yes,
Did you rely on the data that you were given?
yes,
For example, the CDR?
yes.
Did you reach an opinion? And what was your opinion?
Had Mr. McKinney kept his speed down to 30 miles an hour or below and yielded to Mr. Vega in his dive and let Mr. Vega continue around him and let him go on his way, this accident would have never taken place.
Did you see Dr. McGinty's statements?
Yes, I listened to the whole interview.
And did you use some of that to reach your decision as well?
Yes.
What methods did you use certain methods? Did you use certain methods to reach this decision?
Yes.
And what were those?
In the beginning, I observed the videos, and my goal was to get a frame count. These videos have frames. If you watch them, they're a little jerky. You can see it in the video. Those are frames and resolutions. And if I just pick a time, maybe 2 or 3 seconds, and count the number of frames through that time period, I can calculate a number of frames per second. In this case, it's 16 frames per second. And I can use that to measure, let me read this to you. So by using, and I'm addressing you guys here in the jury, by using the Masonic Lodge and the Nissan onboard videos, I was able to determine the video resolution by counting the number of video frames per second. For the Masonic Lodge video, the resolution was 48 frames per second divided by 48 frames by over a period of 3 seconds, approximately 16 frames per second. For the Nissan onboard video, the resolution was 40 frames divided by 8 seconds, approximately 5 frames per second. I also checked the Masonic Lodge video time clock using my cell phone stopwatch to determine if the video timer was in sync with the stopwatch, indicating the video was a second by second in real time. So it was the video counter or the time counter on the video was accurate.
And how did that help you in reaching your decision?
It allowed me to calculate the speeds at various points along the way when these cars come into the views of the videos at different points. And I calculated the speeds based on what the CDR chart told me.
Okay. May I approach you?
Yes, sir.
I'm going to hand you exhibit 63. Do you recognize that?
Yes.
You got a copy of that?
Yeah.
Okay. Will you be referring to that during your testimony? Some of my questions? Okay. How did you use this? And if you'll let me know what page, I can show the jury.
The first would be
Vince laptop.
the first would be,
I'm sorry, not laptop, but yes.
the
I'm
first
sorry.
would be page 19.
Mr. Kilpatrick, what is significant about this document? This is page 19. This one.
This is pre-crash data, most recent event, table 1 of 4. On the left side, you see a time stamps in seconds. This is most of the ACEMs today, the airbag control modules, in a modern car will count down to 5 seconds before impact. If you see a pre-crash recorded status, that means that the entire event was recorded and complete. The third column is the vehicle speed indicated in miles per hour at 5 seconds before impact. The Dodge was running 29 miles per hour at time.
What time was that?
That's 5 seconds before
5
impact.
seconds for impact?
And down at the very bottom, it says 0.1, that's 62 miles per hour.
Okay.
So you can see a progression from 5 seconds to 0, where there's just about a constant acceleration from a low speed to a high speed.
And did you use this CDR to determine the speed of the Nissan truck?
No.
Okay. Did you determine what the speed of the Nissan truck was?
Well, based on the video, if you play the video, you'll see where the truck was right there with the Dodge the whole time until they separated at the intersection.
Is there any particular photographs that you can show that to the jury?
I would direct your attention to figure 67 in my report, page 46, 47.
We don't have. We'll have it up in just a minute.
Report with data exhibit.
Pardon?
Are you gonna make this report an exhibit? Are you gonna make this report an exhibit?
No, you're on. Judge, do we have the laptop?
I've got on the fence laptop.
This laptop? We're plugged up. I don't know. Like, there we go. Yeah. Is this a frame from the Masonic Lodge video?
Yes.
Can you explain what you see there?
This is a frame where the right front corner of the Dodge is just appearing in the video, and can I have a pointer?
Yes.
Can you guys see that? Okay. What I'm trying to illustrate here in this photo, this is a screen capture of the video. And so what I wanted to bring your attention to, this is the edge of the building on the Masonic Lodge, right on the corner. What I wanted to do is I put a line right there through this image to show you right here is where the Dodge right front corner is. It already had passed. It has already passed the corner of the building. If you'll notice, when I draw this line through here, it's approximately lined up with the sidewalk tree. So using this video, I counted the number of video frames, 38 frames, where the front of the Dodge just appeared in this video that you see it, where the right front bumper lines up with the sidewalk tree to where the Dodge crashed into the Walnut Bridge gift shop at the hard pulse. When we play these videos later on, you'll see where the vehicle comes into contact with load-bearing column and it crashes in hard. Then it lifts and rotates and backs out. That initial impact is what's going to trigger the data in this report. And there's going to be other data with rollover and other data with yaw and stuff like that. Let's see. As stated in the video, the Masonic Lodge security video frame resolution was 16 frames per second. 38 frames divided by 16 frames is 2.375. Referring to the Dodge CDR on page 19, we find 2.3 seconds under the timestamp, and we read the velocity associated with 2.3 seconds, and it's 46 miles per hour. So what I'm trying to show is that at this point, the Dodge was going 46 miles per hour.
And did you determine something after this particular screenshot?
Well, that's the whole purpose behind this screenshot,
Yes.
is just to determine the speed.
To reach your opinion, what is the reasoning behind your opinion?
I wanted to use these markers to determine how fast the vehicle was going at certain points down the road. At least initially. But as we look at the videos, we will see where Dr. McKenzie's Nissan is staying right with the Dodge, and they're going the same speed.
Okay, and so that's how you determine how fast the truck is going, the Nissan truck, is it because?
Whatever that Dodge is doing, that Nissan is doing the same thing, speed-wise.
Okay. Did you listen to the testimony? Well, you said you wanted to show the videos. Is there something you want to point out to the jury about the videos?
Yes.
Yes.
Yeah.
Which one?
Let's play the Nissan video first.
Do you recognize this video?
Yes, this is a video from the Nissan.
This is the video from the dash of the Nissan truck.
That's correct. So they come to the Nissan, come to a complete stop here at Manufacturers Avenue. Manufacturers Road. He turns left and to go around this Toyota Prius. And keep in mind that Mr. Vega, his Dodge is right behind him. Now both of them come up to this intersection. This is Market Street. And they stop. Now they're moving, they go into the intersection, to the next intersection. Can you guys hear me okay?
Yes. Move that microphone around.
Thank you.
Okay, now they have stopped at Woodland Avenue. This is the last intersection before the one that Forest Drive. If you'll notice, this little white subcontract car, I made some calculations to find out how fast it was going. Okay, you need to play that again.
You want to play it at the same speed?
Yeah. Okay, before you play, let me explain something. What I'm going to do is show you where the initial contact between the two vehicles took place. And Dr. McKenzie said in his testimony, we all heard it, that he was afraid, he had a sense of fear, and his goal was to not allow the Dodge to get in front of him, and he was gonna try to cut him off. That's exactly what he did. So, what I want you to notice is when we play this video at full speed, when the videos, when these cars are like this and the Dodge comes up, you'll see the Dodge raise up and rotate on the suspension. You know, we got springs and it will bump and rotate a little bit. That's the point of impact right there.
And just for the record, you were holding your left hand up, your right hand up, your right hand was.
This is the truck, this is the Dodge.
The right hand is the Dodge. Are you ready for it to play?
Yeah, go ahead. Can you guys hear me? Okay. I'll do this. Okay, right here you'll see where the Dodge comes up. They're equal in speed, and boom, right there. You see where the car just rolled over? That's the point of impact. And if you'll notice, it almost appears that Dr. McKinney was actually deliberately speeding up, trying to prevent that maneuver. And so doing, he caused the Dodge to go into a counterclockwise yaw and caused it to go out of control. Now, one thing I want to before you change that, one thing I want to show you is this. And I put this in my report. The Dodge, this truck, the Nissan has come to a stop. But look at the speed, 36.39 miles per hour. There's no way that I would ever use the speed in that video to try to tell me how fast it was going because it's not accurate.
Anything else helpful in this video that you would like to present?
I'd go ahead and play it one more time.
Do you want it at the same speed or would you like it?
Slower, just do slow. That'd be good. Because it takes, you have to watch it a few times to really grasp everything. Coming up, the Dodge is coming up, they're parallel, and if you notice, they're going the same speed. You see that raise? That's where the contact took place, and it was only for a second. It was just enough to cause him to go into a yaw and go out of control. And if you would stop the video just about the point of contact, you would know.
2.05.
Okay, stop it. Okay, right here is approximately where the contact took place. If you'll notice, the front of this Dodge is just about right there where you pull in to this gated parking lot at the Masonic Lodge. So the contact took place along in front of this building after it passed the corners. And when you go back and play the other one from the Masonic Lodge, the cars get into this area in that video, you can see where the point of contact was. Go ahead.
At this time, is there any other important data that you would like to present or regarding this video?
I would play it one more time.
Okay.
The Dodge is coming up here. making his move, the contact is very brief, and if you'll notice, the Dodge and the truck and the Dodge are going the same speed until they enter the intersection. That's when Dr. McKinney hits his brakes so that they can separate and go on there. And so he goes to park right behind these cars, and the Dodge, that's what it does, it goes and hits the building. Okay, that's all.
Would you, at this time, would you like to show the Masonic Lodge video?
Yes. Now, this, before you, if you would stop it a minute. In this video, this is where you're gonna see both of these vehicles moving at the same speed. You can see them right with each other. And the Nissan is going the same speed as the Dodge, and you can watch it and see it in this video. See that? Play it again. You know the speed of a small car. The car, I timed the car running about 26 miles per hour. That's below the speed limit. If you see these things, here these two cars are really moving. Go and play it again. Okay, stop it a minute. When these two vehicles get into this area, do you remember what you saw a while ago? Where, in the Nissan video, you saw where when the contact took place, they were in front of this gate right here. Do you remember that? We may have to go back and watch it again. They were somewhere in this area, right here. That's where the initial contact took place. And so when you see these videos, when you see these two vehicles come up here, when you see them get into this area, that's where that initial contact took place. The problem is in this video, you can't see it, you know, because of the perspective. Okay, go ahead. And that shows that the Dodge, the Nissan was right there with the Dodge speed line, no doubt.
Mr. Kilpatrick, are there any still videos that you would like to display to help show that area of impact?
Not really, but I did calculate the speed of the Dodge when its right front wheel rolled over that line. It's 58 miles per hour, based on my techniques, the frame count and so forth. So as the two separated and the Dodge continued heading to the intersection, it continued to gain speed to the point to where it hit the building at 62 miles per hour.
Did you hear the testimony of Investigator Warren about the side swap?
Yes.
And what is your opinion about the side swap?
Well, side swipe is when two cars come in and one car is going faster than the other, and they do that. You'll see paint, you'll see a swap in the paint, and you'll see body damage where the two vehicles come into contact with each other. In this case, when the when the truck and the Dodge get into each other, they stay that way for about a second or so. And there's going to be some relative movement to cause a little bit of crush damage, what we call dynamic collapse. And there's not really that much damage to these vehicles. So they're kind of bumping and grinding with each other until they separate, and then they move on. And so I wouldn't classify this as a side swipe. This is a strike.
Strike.
One vehicle comes into the other.
Okay. And you testified earlier that this contact put the Dodge van into a yaw,
Counterclockwise yaw.
And is there evidence in the data that you looked at that Mr. Vega tried to correct that or get out of that?
Yeah, because in the CDR charts.
I'll need the overhead, Judge.
On page 20, the CDR chart is labeled as pre-crash data, most recent event, table 2 of 4. It's page 20.
It's on the screen behind you. Can you tell us about those movements where the Dodge is trying to correct itself, or the driver of the Dodge is trying to correct itself?
According to the CDR report, according to the CDR chart, a left turn is positive in this chart right here. So you can see when he was steering, you can see various steering wheel inputs. And a negative number is a right-hand steer. So what he was trying to do is to try to counter-steer his way out of this out-of-control position. And you can definitely see right here and around these numbers, at one point, it turned to the right 119 degrees. And then just about 0.5 or 0.6 seconds before impact, then he turned back to the left. You can see these positive numbers. And he did, and for some reason, he steered back to the left going into that building.
And you don't know why he turned left, do you?
No.
Okay. But normally when you have some people just classify as a fishtail where your rear end comes to the right, you steer into it
That's
to
right.
correct it.
And that appears to be what he was trying to do.
Okay. And before this this clockwise turn to the right,
No, but steering into it,
yes,
he's trying to counter, is what you're saying?
yes.
Okay.
When he makes that turn to try and gain control of the vehicle, is this after the impact?
Let's see. Of course it would be.
Yes,
Yeah,
okay.
absolutely. Yeah.
Looking at the data and the evidence that you have been provided to in this case, plus listening to Dr. McGinty's testimony, again, can you summarize what caused this accident?
Mr. McKinney's Dodge, and Mr. McKinney stayed in his throttle and tried to prevent Mr. Vega from getting in front of him. He said he was scared and he did not want allow him to get into his lane because he feared what he might do next. So he testified to it. And so he stayed in the throttle in that truck and tried to prevent him from doing that. In doing so, it sent the collision sent Mr. Vega's Dodge out of control, causing this crash.
Is that summary consistent with the evidence that you've looked at in this case?
Yes.
Just a moment, Your Honor. That's all the questions I have. Your witness.
Mr. Kilpatrick, I introduced myself just a little bit ago. I have some questions for you, please. Have you ever worked with law enforcement?
No.
Okay. Have you ever participated in any law enforcement training, sir?
No.
Reviewing your CV, I did not see listed trainings in toxicology, pharmacology, medicine, physiology, or impairment science. Do you have trainings in those fields, sir?
No.
Okay. You have not attended wet labs where you get to see how alcohol impacts individuals' reflexes, judgment, or reaction times. Is that fair to say?
Correct.
Thank you. You have no training or experience in driving under the influence investigations or detection, correct, sir?
That's right.
Okay. You do not have training in drug or alcohol recognition or impairment science. That's also correct.
That's correct.
Are you familiar with Tennessee law regarding the right of way when a vehicle is changing lanes?
Off the top of my head, no.
Okay. And therefore, are you familiar with what Tennessee law says regarding the responsibility of the driver who seeks to change his lanes?
At this point, no.
Thank you, sir. What percentage of your business is for supporting litigation?
100%.
100%. What percentage of your business is related to accident reconstruction involving motor vehicles driven on roadways?
I would estimate 30%.
Estimate 30%, okay? And how many accident reconstructions on motor vehicles driven on roadways do you personally conduct each year?
Say one.
What percentage of your time is actually spent on accident reconstruction involving motor vehicles driven on roadways, sir?
On a percentage-wise basis, 30%,
Thank you. But one a year.
1 year.
What percentage of your reconstructions involving motor vehicles driven on roadways have involved vehicle to pedestrian crashes, sir?
Maybe 1 or 2.
Okay, so less than 1%?
Yeah.
Okay. How many of these reconstructions do you handle a year?
Motor vehicle what? Motor crash reconstruction?
Motor vehicle to pedestrian.
Probably 0 at this point.
So therefore, you have not dealt with any cases involving multiple pedestrians.
That's true.
And including this case, is it one then for how many have involved multiple vehicles and pedestrians?
Ask that one more time.
Yes, sir. Including this case that you're here for today. How many have involved multiple vehicles and pedestrians?
Probably none.
Who's your client in this case?
Mike Little.
Okay. Your client is not Randy Vega?
Well, that's his time.
What are you charging an hour?
The state paid me $200 an hour.
Okay. Is that the same fee you charge all of your clients?
No,
You're billing for your testimony right now, correct?
that's correct.
Been on the stand for a little while, made a couple of $100s. Is that correct, sir?
Yeah.
When do you get paid, before or after your testimony?
In this case, it's after.
Okay. Do you advertise
Yes.
online?
Yeah, I have a website.
You've provided an opinion in this matter, correct?
That's correct.
So, and you've also provided a report,
That's correct.
certified report,
That's correct.
about a dozen days ago. Is that fair to say? Roundabout.
I've turned it in. Let me look at my notes.
Okay. The most recent certified report is in fact May 25th of this year, correct?
That's correct.
Thank you.
And that would be it. Yeah, I don't know why I didn't think of that. That's right.
That's okay. And then there was another report, less than 24 hours generated. Is that correct?
Yes.
Okay. 2 certified reports.
Well, the second was to add some additional information and fix the typos.
Okay. Tighten up the language a little bit. Is that fair? Tighten up the language of the first report.
That's right.
2 reports, the second report's to tighten up the language of the first report.
That's right.
Okay. Thank you, sir. How many times did you meet with members of the Chattanooga Police Department?
I don't think I've met with them at all.
Okay. How many times did you meet with members of their traffic investigation team? Still 0?
0.
Okay. How many times did you meet with special agents of the Tennessee Bureau of Investigation's Crime Lab?
0.
Okay. How many employees does your business have?
1.
Okay. Are you the sole employee?
Yes.
Okay. Do you seek peer review of your accident reconstructions?
No.
So you generate opinion, and this is the opinion you present, and you don't reach out to anybody else, correct?
No.
Yes or no?
No. No.
You do not do that.
That's right.
Thank you, sir. For you to prepare your opinions, you would have to engage in some assumptions. Is that fair to say?
Yes.
Does your client rolling through a stop sign shortly before this crash come into your analysis?
Ask me that one more time.
Does your client, And I'm sorry, I said your client. Does Mr. Vega,
Yes.
does Mr. Vega's rolling through a stop sign come into your analysis in this accident reconstruction?
No.
Okay. Your report states in substance that the crash would not have happened if Dr. McGinty had remained at or below speed limit and yielded. Is that correct? Is that a fair summary of what your report says?
Yes.
Okay. Your opinions, again, depend on some assumptions. Would one assumption be what Vega would have done next had this not occurred?
Yes.
Okay. Would one assumption be whether there would have been no contact at all?
If Dr. McKenzie had kept his speed.
It's Dr. McGinty, but please continue.
I'm sorry.
It's Dr. McGinty, but please continue.
Had he kept his speed slow and allowed Mr. Vega to go around him, then this accident would have never taken place.
I understand. Okay. That's your opinion today.
That's correct.
Okay. So is another one of your assumptions here whether lane merging would have even succeeded if Dr. McGinty was not there?
Ask me that one more time.
Okay. Is another assumption that you have is that if Dr. McGinty was there, you're just assuming Vega would have successfully made it to that other lane of travel?
That's correct.
Okay. Is it fair to say that if impairment's a factor, that he could have had other issues in shifting that lane? If impairment's a factor. It's possible. So that's an assumption. Okay.
I'm not qualified to answer that question because I have no training in impairment.
Fair enough. Thank you, sir. Another assumption is that if Dr. McGinty had not been there, the pedestrians would have been unaffected.
In this case, that's correct.
Okay. Again, no training and experience in determining whether somebody's impaired and able to maneuver safely. Correct? Okay.
Ask that one more time.
You have no training or experience in determining whether somebody who is impaired can navigate the lanes, the roadways of the state of Tennessee safely. Correct?
That's correct.
Thank you, sir. When you say that the crash would not have happened, that is a hypothetical scenario that you have created, correct?
I would say no,
Okay.
because, like I said, in my opinion, had Dr. McKinney kept it slow, had Dr. McKenzie kept his speed low, allowed Mr. Vega to go around and yield to Mr. Vega, let him go around him, then this accident would never take place.
Okay. And then that's based on the previous assumptions that we just discussed, that everything was going to go perfectly.
It is an assumption because at that point in time, I don't know what Mr. Vega had planned after that. And Mr. McKinney.
You beat me to it. That was my next question. You cannot know for certainty what each driver would have done.
That's correct.
Okay. Your report says that contact had the appearance of a police maneuver known as the precision immobilization technique or PIP maneuver. This is an analogy and not a measured ACM parameter, correct?
That's that one more time.
Okay. You mentioned a PIP maneuver in your report. You're using that as an analogy, correct?
Yeah, that's correct.
Okay. It is not your opinion that Dr. McGinty was actively engaged in a trained law enforcement PIP maneuver.
No,
It's an analogy.
that's an analogy. That's correct.
You did not test every reasonable alternate scenario that could follow from these vehicles running side by side, did you?
Run it by me again.
You did not test every reasonable alternate scenario that could follow from these vehicles traveling side by side, correct?
No,
You inspected the scene in 2026 and determined the roadway had been altered by the Department of Transportation, correct?
that's correct.
You concluded that the roadway had been changed since the crash.
That's correct.
Okay. The measurements that you take occurred, and when you went out to the scene was after the roadway had been modified, correct?
That's correct.
So the measurements that you take and you took at the time were not based off of the actual scene, correct?
That's correct.
Because it was different.
That's correct.
I'd like to talk about the reliability of your analysis. Page 47 of your first report, page 50 of your second report say that Dr. McGinty's dash cam video is 5 frames per second. Good Wars, could you play Dr. McGinty's dash cam? You're on. Can we have State's laptop, please? And Jim reports when we have a signal, do you mind hitting play? Yes, sir. I'm going to ask you to watch this video for just a brief moment. There's a car driving. Somebody's run across the street. Fair to say?
Yes.
Okay. Smooth video. Would you agree?
It appears to be, yes.
Yes, it certainly does so. It does not appear to be 5 frames per second, correct?
I would say no.
So all the calculations that you made based off of this video are therefore incorrect. If you are assuming that this video is 5 frames per second, correct?
Well, what I would like to do is explain something.
Please.
In the course of measuring these frames per second, you take the mouse, you put it on that slider, you move barely, and watch the frames flip, 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 and you get enough of them, and then watch the timer, and then I can take the number of frames divided by the elapsed time and calculate frames per second. In this case, with the Nissan video, it may or may not be correct because, and just keep in mind one thing, I did not base my analysis on this video. I based my analysis on the Masonic Lodge video.
Okay. But you referenced this video in your report as being 5 frames per second, correct?
Yes.
Okay. Did you look at the metadata of this video?
No.
Okay. Passing you a photograph, sir. Could you tell the jury what this reflects? You would agree that this is a screen grab of that same video?
That's right.
Okay. How many frames per second is reflected? A little bit here at the bottom.
Resolution 16 bits, is that right?
No, sir. The frames per second, it should say 60.
Oh, frames, okay, I see it.
Yes, sir.
60 frames per second.
I appreciate you taking the time to do that, sir. Page 44 of your old report, 49 of the new report, you're analyzing the speed that is reported by the airbag control module. You say that in your report that by the time the Dodge had rolled into the intersection in figure 73 above, it was traveling more than 58 miles per hour. Mr. McGinty was applying the brakes of his Nissan to slow down. You are not taking into account, would you agree, the differing revolutions of each one of the tires at that time. Is that a fair statement?
I looked at the chart, but now what was your question again?
In making that determination, you were not looking at any other data, including the actual revolutions each tire was making individually, correct?
At the 58 mile per hour number?
Yes, sir.
Probably not.
Probably not. In fact, your client might have actually been going a little bit slower than 58 miles, or I said your client again, I'm sorry. The defendant might have actually been going a little bit slower. Is that fair to say? Than 58 miles an hour?
Possibly maybe a mile an hour or so.
Okay. Your testimony was, it almost appeared like he, referring to Dr. McGinty, was speeding up. It almost appeared like he was speeding up. That statement doesn't actually mean anything, does it? You're not actually saying anything. It almost appeared like he was speeding up.
Where is this at?
No, that was what you testified to just a moment ago.
What page in the 525?
No, that was just your testimony, sir. I was just
I'm gonna
asking.
read it myself.
Okay, please.
Tell me what page you're referring to.
Oh, that's not referring to a page. That's just your testimony a moment ago. I'll move on. You put in your report that you use a stopwatch app on your cell phone to record timing. Your use of your stopwatch app is mentioned throughout the report, as well as your rate of error at some point. You're not actually using a physical stopwatch, are you? You're using, your report reflects in both reports that you're using an app, correct?
I'm using the stopwatch on my cell phone.
Okay.
But I only mentioned it one time.
Okay.
Maybe twice.
Maybe twice. Pages 52 and 53 of your second report, pages 47, 49 of your first report. Now, would you agree that your calculations based off of that are only as good as your reflexes?
And checking the difference between the two?
Yes.
That's correct.
Okay.
And when I hit the stop, it did not show exactly, but it was very, very close.
In fact, you're so concerned about that, you take 8 measurements. And then, no? Okay.
I did not rely on that. I was showing the court that you do not want to try, you don't want to do this.
Okay.
I put it, that has nothing to do with my opinion.
Okay.
Just strike that.
There is-
They can put it in there.
Between your 2 reports, you testified earlier that the language is substantially similar. Yes? You're tightening up the language between the second report and the first report.
Yes.
Okay. That's not entirely accurate, is it?
That depends on, you have to show me what you're talking about.
I'll tell you about it. You take a statement out between the 2 reports. Do you recall doing that?
Probably, yes.
Okay. On page 31 of your original report, you include, it was determined through a police search warrant that Mr. Vega was under the influence of alcohol.
I remember that, yes.
Okay. And then that is missing from the second report.
The reason I took it out because it did not flow well in the report, and because of the fact that I'm not qualified to render an opinion, I took it out.
Okay. So you felt qualified the first time you made that report.
No, it's just, because I read it, I just put it in there, and I thought better of it and just took it out in the new edition.
Are you in the habit of just including things that you read into your report that therefore are not pertinent?
No,
Okay. So is this just a one-off?
that's right.
Okay. Airbag control module report. It's page 20 of the AC, referring to the ACM.
Page 20.
Yes, sir. On the ACM report itself of the defendant, Randy Vega. Let's talk about the steering inputs, which you specifically address in both of those reports.
Right.
You explain the sign convention this way: positive steering input means a counterclockwise or left turn steering wheel input. Is that correct?
Yeah.
Negative numbers mean right steering, positive numbers mean left steering. Your report states that by looking at page 20 of your client's, again, the defendant's CDR report, he turns his steering wheel counterclockwise or left, he turns right to try to correct the yaw, correct? You agree that the ACM data reflects that the gas pedal was fully depressed at the time of impact?
Fully compressed, yes.
You would also agree that when your client loses control, the best thing to do is decelerate, correct?
That's correct.
Okay, and you agree that the CDR ACM steering chart is important to understand what the driver was doing with the steering wheel prior to impact, correct?
Yes.
Okay. You agree that your report says the CDR chart defines positive steering the same as you defined it, correct?
Ask me that again.
Okay. Your report is in line with the ACM report as to what a left turn steer is, what a right turn steer is.
That's correct.
Okay. So let's go into this a little bit more. At -5 seconds, the steering input is negative, correct?
At -5 seconds.
Yes, sir.
uh,
Okay.
Yeah, -5 seconds is -6 degrees.
Okay. -4.9, still negative?
Yes.
4.8? 7, 4.7, 4.6, 4.5 through roughly 4.1 seconds. The values remain in the negative. Around -8 degrees, is that fair to say?
Yes.
Okay. And then by about -3.6, 3.5, 3.4 seconds, those values are still negative, correct?
That's correct.
Okay. Now by the next entries around the -3 second mark, the steering input values become positive. Would you agree with that?
That's correct.
Okay. And for example, on page 20, it shows positive values of +12, +25, +35. Then it drops down a little bit, 33, 23, 40, 14, 9, 9, 7, roughly through -2.9 and -2.1 seconds. Still correct.
That's correct.
Okay. And under your own sign convention, positive values mean left steering, correct?
But it's not my side convention, it's the convention of the report.
Thank you. So the ACM data shows a steering reversal from right to left before the latter phase you discussed in your report. Is that correct?
Yes.
Your final report never tells the jury and does not hammer out that there was an earlier right to left steering reversal around the -3 second mark. Is that correct?
That's correct.
Okay. You make an assumption that your client is attempting to correct a force yaw between -2 seconds and -0.9 seconds, correct? Okay, your portion of the report leaves out an essential element in reference to this, that your client should not be depressing fully the accelerator. Is that correct?
Run it by me again.
Whenever your report says that your client is trying to correct a force yaw, you don't mention that he has fully depressed the accelerator in this portion when you make that statement, correct? In fact, he almost redlines his tachometer as he depresses the accelerator. Would you agree with that statement?
Ask me one more time.
He is close to redlining his tachometer as he's depressing that accelerator. Would you agree to that?
Let me look at the chart before I answer that. Okay, ask me that one more time.
Okay. You agree in no way. He has almost redlined the tachometer whenever he is hitting the accelerator. Is that correct?
I don't know what the red line of that engine is,
Okay.
but the engine is speeding pretty high.
Did you review photographs of the dashboard that would have shown you that information?
I remember seeing that, yes.
Okay, but you don't recall it specifically for your testimony today?
No.
Okay. Then about -2 seconds, the steering input values become negative again, correct?
Yes.
At -2 seconds, the value is negative and it becomes more negative, -1.9 and -1.8 seconds, correct?
Yes.
And
Kind of switching.
We're -2 seconds moving to 1.8 seconds.
Go back to
Take your time. Page 20 of the ACM.
thank you.
Yes, sir.
Yes, okay.
Okay. So by about -2 seconds, the steering input values become negative again, correct?
Yes.
At -2 seconds, the value is negative and it becomes more negative at -1.9 and 1.8 seconds, correct?
That's correct.
In fact, page 20 of the values, we hit -8, -34, -45 as the sequence progresses. Would you agree with that statement? And later in the same sequence, the steering inputs get even more negative. We're looking at minus 92, minus 113, minus 119. Would you agree with this? So that means the ACM does not show one simple steering correction, does it?
So starting at point 2, it goes from a left-hand steer to a right-hand steer, and it continues the right-hand steer all the way down to 0.8 seconds before impact, 113 degrees. And that tells me he's trying to counter steer his way out of the yaw.
Okay. And then the ACM values change sign again at minus 0.5 seconds, correct?
Now, ask that again.
The ACM values change sign again near 0.5 seconds, correct?
That's correct.
Okay. You mentioned that in your report,
That's right.
that he steers left. But at this point in your report, you stop mentioning the degrees that he turns, don't you?
Yes.
Okay. So while it acknowledges that there's a left-hand turn, it certainly leaves out that it does not assign degrees of steering at this point, correct?
That's me again. You're going pretty fast.
Yes, sir. So at this point in your report, when you are acknowledging that there is a left-hand steer at 0.5 seconds, you do not break down the degrees that he is turning his wheel. Is that correct? Your report.
And which timestamp?
0.5 seconds, where you acknowledge that he's beginning to turn left down to point.
Yeah, and then he
minus
turns
0.1.
back right.
Yes,
He
sir.
turns back, yeah.
So at that point in your reports, both your reports, you are not assigning degrees of turning. You're just acknowledging he has turned left.
That's right.
Okay. You do not point out that it's approximately 140 degrees of steering input from right to left at that final point, correct?
I'll have to go back and look, but
That's probably about right. You agree that this is his most dramatic change in steering input that is captured by the ACM, is that correct?
Yes.
You testified to a fishtail about this last half second. That verbiage doesn't show up in your reports, does it? Last half second.
I never said fishtail.
I think that you didn't testify a little bit ago that would have been similar to a fishtail?
I don't remember ever using the term.
Okay. Your report does not set out the full sequence of the defendant's steering reversals shown on ACM page 20, correct?
That's that one more time.
Your report does not set out the full sequence of the defendant's steering reversals shown on ACM page 20, correct?
That's correct.
Okay. It does not tell the jury that your client was already in a slight right steering input before the later sequence you described, correct?
Correct.
It does not tell the jury that the data shows a right to left change around the minus 3 second range, correct?
That's correct.
It does not tell the jury the degrees of your client's steering input at the time of final impact, correct? Instead, your report focuses on a narrower interval and presents only the later left to right reversal with a brief mention of a final steering input to the left. Would you agree with that? Okay. So your steering discussion was selective.
I said that one.
Your steering discussion in your reports was selective.
I wouldn't say selective. I was just pointing out the obvious of what was going on at that time.
Okay. So you're asking this jury to accept your reconstruction as a complete explanation of the defendant's steering behavior. Is that correct?
Yes.
But your own source data shows more steering activity than what you chose to describe in your reports, correct?
That's true.
Okay. You're offering your opinions to a reasonable degree of scientific and engineering certainty, but you chose to exclude facts that might contradict your conclusions, correct?
I would agree with that.
Your report is wrong in some areas then, especially regarding Dr. McGinty's video. Would you agree with that? Regarding the frames per second.
In that case, yes.
Your report minimizes the defendant's actions, even disregarding the near 140-degree turn into the family, correct?
One more time.
Your report minimizes your client's actions, even to the point of disregarding the final 140 degrees, approximate steer to the family, correct?
Not giving me enough time to process this information.
We can move on. You do not assign any responsibility to the defendant whatsoever, yes?
That's correct, yes.
That's correct.
That's correct.
You opine that the defendant changed his lanes while Dr. McGinty was tragically in his way, yes?
Yes.
Is it your opinion today that the responsibility of the person maintaining their lane of travel to get out they're supposed to get out of the way of somebody coming into their lane of travel?
Say it one more time.
Is it two people are driving, somebody's getting over. Is that person who's maintaining their lane of travel supposed to pump the brakes so this other person can get over?
Yes.
Okay. It's not the responsibility of the person changing their lane of travel?
Well, both have responsibility.
Oh,
Yes, both have responsibility to try to avoid a collision.
so that's a little bit different than what we just heard testimony about a minute ago. So it's possible that there is some responsibility to assign to the defendant. Is that correct? Take your time.
I would like to withdraw that answer.
Which answer?
Hmm?
Which answer, sir? Please.
Well, you're coming at me pretty hard with a lot of different questions. And
Yes.
You're not giving me enough time to process it.
We'll take a step back. Your opinions do not assign any responsibility to the defendant when he is changing his lane of travel. Is that correct?
That's correct.
Is it your testimony today that is the responsibility of the person maintaining their lane of travel to get out of the way of somebody coming across into their lane?
Now, ask that one more time.
Is it the responsibility of the person maintaining their lane of travel to get out?
As in Mr. McGinty.
Is it the responsibility of the person maintaining their lane of travel to get out of the way of the person coming into their lane?
Run that by me again.
Is it the responsibility of the person maintaining their lane of travel to get out of the way of the person that is coming into their lane?
To avoid the collision, yes.
To avoid a collision.
That's right.
Who would be causing the collision in that case?
In this case, Dr. McGinty.
Who would be causing the collision in this situation where somebody's maintaining their lane of travel and somebody comes over into their lane? Who's causing that collision?
Dr. McGinty.
I'm not asking that question. If someone is maintaining their lane of travel, I'm not talking about Dr. McGinty at all.
You got it.
I'm not talking about the defendant, okay? You're driving down the road and somebody's coming over into your lane of travel. Whose responsibility is it to make sure that that maneuver is conducted safely?
That'd be the person maintaining the lane of travel. Because if there's going to be a collision and the person turning into that left lane, the person maintaining their lane of travel, if they're going to want to avoid a collision, they're going to hit the brakes to back out and give this other car right away to avoid a collision.
When you're driving down the road and you want to get over, do you just turn the wheel?
No,
Why not?
you have to look around and keep your head on a swivel.
Sure.
Make sure that, nobody, that you got, clearance to do that.
Okay. Well, if it's their responsibility, if you're trying to get to the left-hand lane and someone's there, why don't you just come over? It's their responsibility to get out of the way. Do you have an answer for that?
If somebody's in lane of travel, going to speed, and another car's coming over to get in front of them, to avoid the collision, the person in that lane of travel should hit the brakes to avoid the collision.
Okay. Thank you.
It's called last clear chance.
You be ready.
Kilpatrick, I'll talk a little slower.
Okay.
Did I hire you in February of
Yes.
this year? Okay. And you accepted the low rate of $200 an hour?
That's right.
Okay. Do you work for free?
No.
Okay. You graduated from North Carolina State University, is that correct?
Correct.
In engineering?
Yes.
Okay. And that was how many years ago?
1990, so it's 36 years ago.
Okay. And you have been an engineer ever since then? Licensed in multiple states? Okay. You are an engineer. You're not just a accident reconstruction sergeant. Okay. What other fields do you work in?
I'm one of the top forklift experts in the United States.
Okay.
I used to work for Frazier Equipment. I have a lot of experience with it. I'm a certified crane operator and a crane expert. I spent a year in school getting certifications to operate automobile cranes. And the reason I did that was because I get called into crane cases every once in a while, and I'm involved in at least one right now.
Okay. And so you're not accident reconstruction. You are an expert in it, but you do other things as well. So that would describe why you maybe only do one accident reconstruction. Okay. And this one you've been on since February, correct? This one here, we're here today on?
I'm working on that case.
You were hired to look at this data. Is that correct? You were provided with most of the evidence in this case.
That's correct.
Okay. And you were asked to determine what caused this accident. Is that correct? Right. Did I ask you to determine what happened after what caused this accident?
No.
Okay. Let's make sure we're clear on this lane change. So when you are in a 2-lane or 4-lane road and 2 lanes are going in one direction, 2 lanes are going in another direction, and you have 2 cars that are going at speed limit, so they're going at the speed limit, and one is in the right lane and one is in the left lane. Should anybody cut over on anybody?
No.
Okay. You have a car that pulls ahead of you on the right lane. So, for example, in this case, a van, okay, pulls ahead of you, and it's clear, and the driver of the person in the left lane, would be the truck in this case, knows that individual is going to come over. Should he yield? Should the truck yield?
Should he yield?
The truck.
Yes.
Yes. Or should the truck hit his gas?
He shouldn't do that.
You and I discussed over the last few months about your report.
Yes.
And you like to make sure you get it right.
That's correct.
Okay. And so we talk. You mentioned to me about your report, and you tell me I like to update it. I review it. I double check it. I review it. I double check it. I review it. That's
correct.
That's
just
Mr.
my
Kilpatrick.
nature. I tweak the report right up to the point to where I can't tweak it anymore.
Okay. You want to do the best you can to produce a good report.
That's correct.
So some of the data that you did not include in your report, that doesn't mean you ignored it. You just didn't include it in your report.
That's correct.
You're focused on what caused the accident.
That's correct.
And in this case, you have determined that Dr. McGinty driving the Nissan truck is the one that caused this accident.
That's correct.
Based on all of your review to a scientific certainty.
That's correct.
You're looking at the mechanics of this. You're looking at the data of this. You did listen to, is that correct?
Yes.
And you did listen to, you watched the trial this week.
Yes.
Okay. And you made some observations about the other testimony that took place, like the side swapping.
Yes.
Okay. And you disagreed with that. Is that correct? And you considered the dash cam video.
Yeah.
Do you know anything? Were you provided with any information about the dash cam video? In other words, what its brand was?
What now?
The brand.
No.
No. Okay. Do you know how that? You don't know anything about that dash cam inside a Nissan truck.
No.
You just know that there was one there,
That's right.
and you saw the video that came from that dash cam. Never were provided with what kind of camera it was,
That's correct.
how it operates, how it captures video.
That's correct.
Knowing that would have been a little more helpful, maybe.
Is that one more time?
Knowing what kind of camera it was, how it operated, how it collected information and its timing and all that. I don't know about cameras, but that would have been helpful in understanding this dash cam video.
That's correct.
This dash cam video was located in a Nissan Titan truck, is that right? And it's positioned where you cannot see everything.
That's correct. As a matter of fact, the lens was dirty on the outside. You can see some. If you play the video, you can see where the lens is not totally clear.
Was the date correct on that dash cam?
No.
Yeah, was the GPS coordinates correct on that? Was it limited or was it not reliable?
The speed I wouldn't rely on at all.
Okay. But you said you relied on the Sonic Lodge video.
That's correct.
Okay.
Totally.
You were able, that was a video that the camera that captured, it's not inside Mr. McGinty's truck. It's on a building that captures everything after the corner of that building to the accident site.
That's correct.
Okay. No, just a moment, Your Honor. That's all I have.
Good, you're right. All right. Patrick, you may step in.
Time to stand up. Who owns this? Can I have it?
Keep record.
Oh, okay.
Any other witnesses for the defense?
No, Your Honor.
State the offer, can you revoke?
No, Your Honor.
Let's go get her all the we're going to hear in this case. I didn't talk with the attorneys about next steps. It seems the jury room, and we'll bring it up. Council Pritchett.
Yes.
Okay, just ready to go back. Okay, sure.
Jerry's in the yard.
Please be seated. After understanding you've chosen to finish today and come back Monday instead of Saturday, is that correct? I'm going to read you some jury instructions. I'll have to type them down. They will cover some aspects I know you've talked about quite a bit. So just pay attention and give me a copy of this when you go back.
Members of the jury, the evidence in this case has been completed. Will now be instructed as to the law applicable in the case. This covers your duties and the general rules that apply in every case. It also covers the offenses that are charged, included in the indictment, and lists their elements. It includes some rules that you must use in evaluating particular testimony and evidence. Finally, it also includes the rules that you must follow in the deliberations of the jury room, the possible verdicts that you may return. It is your duty to carefully consider all of these instructions. The order in which these instructions are given is no indication of the relative importance. Moreover, do not assume that because a particular instruction is given, it suggests anything about the facts of this case. You should not single out any one or more instructions to the exclusion of one or more others, but you should consider each instruction in light of and harmony with the others. Counts 1 and 2 of indictment 317-849 charged the defendant Randy Vega with the offense of vehicular homicide of Ana Paso Rodriguez and Jonathan Davia, respectively, by intoxication on or about November 25th, 2023, in Hamilton County, Tennessee. Each charge includes the following offenses: vehicular homicide by intoxication, reckless homicide, vehicular assault, criminally negligent homicide, driving under the influence, and assault. Counts 3 and 4 of indictment 317-849 charged the defendant Randy Vega with the offense of vehicular homicide of Ana Paso Rodriguez and Jonathan Davia, respectively, reckless conduct on or about November 25th, 2023, in Hamilton County, Tennessee. Each charge includes the following offenses: vehicular homicide by reckless conduct, reckless homicide, criminally negligent homicide, and assault. Count 5 of indictment 317-849 charged the defendant Randy Vega with the offense of vehicular assault of Octavio de Paz on or about November 25th, 2023, in Hamilton County, Tennessee. This charge includes the following offenses: vehicular assault, driving under the influence, and assault. Count 6, indictment 317-849, charges the defendant, Randy Vega, with the offense of reckless aggravated assault of Octavio Deva Paz on or about November 25th, 2023, in Hamilton County, Tennessee. This charge includes the following offenses: reckless aggravated assault and assault. Count 7 of indictment 317-849 charged the defendant, Randy Vega, with the offense of reckless endangerment of the public at large on or about November 25th, 2023, in Hamilton County, Tennessee. This charge includes the following offenses: reckless endangerment and reckless endangerment without a deadly weapon. Counts 8 and 9 of indictment 317-849 each charged the defendant, Randy Vega, with the offense of driving under the influence on or about November 25th, 2023, in Hamilton County, Tennessee. Each charge includes the following offense: driving under the influence. The indictment in this case is a formal written accusation charging the defendant with one or more crimes. It is not evidence and does not create any inference of guilt. To indictment 317-849, the defendant, Randy Vega, pleads not guilty. The plea operates in law as a denial of every allegation of guilt contained in the indictment and every element of fact in the offenses charged in the indictment. The law presumes the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all the evidence in the case you determine beyond a reasonable doubt that the defendant is guilty of an offense charged or included in the indictment. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. This burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state has the burden of proving beyond a reasonable doubt all the elements of the offense, and that the offense was committed before this indictment was found and returned on July 17, 2024. The state has the burden of proving by preponderance the evidence that an offense charged or included in the indictment was committed in Hamilton County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. The venue of an offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that an offense charged or included in the indictment was commenced or consummated in Hamilton County, Tennessee, you must return a verdict of not guilty. At times during the trial, I rule upon the admissibility of evidence. Do not concern yourself with these rulings. Either by such rulings, these instructions, or any other remarks that I've made, don't need to indicate any opinion as to the facts or what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law. They are not evidence. If any statements are made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts of this case. You are also the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in the light of your own observations and experience in life. Any person who commits the offense of vehicular homicide by intoxication is guilty of a crime. If you find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim by the operation of motor vehicles, and 2, that the defendant acted recklessly, and 3, that the killing was the proximate result of the driver's intoxication. In the context of this offense, a person acts recklessly with respect to the circumstances as a result of his or her conduct when he or she acts with an awareness that conscious disregard of a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The element of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally with respect to the nature or result of his or her conduct when he or she acts with a conscious objective or desire to engage in conduct or cause the result, and the person acts knowingly with respect to the nature, the circumstances, or the result of his or her conduct when he or she acts with an awareness of the nature of his or her conduct, the circumstances exist, or that his or her conduct is reasonably certain to cause the result. If recklessness establishes an element of offense and the person is unaware of the risk of his voluntary intoxication, the person's unawareness is immaterial in a prosecution for that offense. Voluntary intoxication means intoxication caused by the substance that the person knowingly introduced into the person's body, the tendency of which causes intoxication was known or ought to have been known. Motor vehicle means every vehicle, including a low-speed vehicle or a medium-speed vehicle that is self-propelled, excluding electric scooters, bicycles as defined in 58, 55, 8301, motorized bicycles, personal delivery devices, and motorized wheelchairs, or any vehicle including a low-speed vehicle or medium-speed vehicle that is propelled by electric power obtained from overhead trolley wires but not operated on rails. Low-speed vehicle means any four-wheel electric vehicle, excluding golf carts, whose top speed is greater than 20 miles per hour, but not greater than 25 miles per hour, including neighborhood vehicles. Medium-speed vehicle means any four-wheel electric or gasoline-powered vehicle, excluding golf carts, whose top speed is greater than 30 miles per hour, but not more than 35 miles per hour. Vehicle means every device in, upon, or by which any person or property is or may be transported or drawn on a highway, excepting devices used exclusively on stationary rails or tracks. Approximate result means a result which in a natural and continuous sequence is a product of an act occurring or concurring with another, which had it not happened, the result would not have occurred. Intoxication is defined as acting under the influence of an intoxicant. The expression under the influence of an intoxicant covers not only all the well-known and easily recognized conditions and degrees of intoxication, but also any mental or physical condition which is the result of taking an intoxicant in any form, which deprives one of that clearness of mind and control of oneself which one would otherwise possess. In this situation, it would not be necessary that the person be in such a condition as would make him guilty of public drunkenness. The law merely requires that the person be under the influence of an intoxicant. The degree of intoxication must be such that it impairs the driver's ability to safely operate a motor vehicle by depriving the driver of the clearness of mind and control of himself which he would otherwise possess. Evidence from a blood or breath alcohol test that there was at the time alleged 0.08% or more by weight of alcohol in the defendant's blood creates an inference that the defendant was under the influence of such intoxicant and that the defendant's ability to drive was impaired. This means that if he finds from the proof that the defendant was found by the means of a blood test that had 0.08% or more by weight of alcohol in the defendant's blood, you, the jury, are permitted to infer that the defendant was under the influence of such intoxicant and that the defendant's ability to drive was therefore impaired. However, you are never required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by the evidence in this case warrant any inference which permits you, the jury, to draw from any blood test result. Also, the inference may be rebutted by other evidence and circumstances. It is for the jury to determine, after consideration of all the evidence, whether to make the inference which the law permits, the correctness of such inference, and what weight is to be given to such evidence. Any person who commits the offense of vehicular homicide by reckless conduct is guilty of a crime. You find the defendant guilty of this offense. The statement should prove beyond a reasonable doubt the existence of the following essential elements. One, that the defendant killed the alleged victim by the operation of a motor vehicle, and two, that the defendant acted recklessly, and three, that the killing was the proximate result of conduct creating a substantial risk of death or serious bodily injury to a person. In the context of this offense, a person acts recklessly with respect to the circumstances or result of his or her conduct. He or she acts with an awareness but conscious disregard of a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The element of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct. If he or she acts with a conscious objective or desire to engage in the conduct, cause the result, and a person acts knowingly with respect to the nature, circumstances, or the result of his or her conduct. And he or she acts with an awareness of the nature of his or her conduct, that the circumstances that exist, or that his or her conduct is reasonably certain to cause the result. If recklessness establishes an element of an offense and the person is unaware of the risk because of voluntary intoxication, the person's unawareness is immaterial in the prosecution for that offense. Voluntary intoxication means intoxication caused by a substance that the person knowingly introduced in the person's body, the tendency of which to cause intoxication was known or ought to have been known. Motor vehicle means every vehicle, including a low-speed vehicle or medium-speed vehicle that is self-propelled, excluding electric scooters, electric bicycles as defined in 55B301, motorized bicycles, personal delivery devices, and motorized wheelchairs, or any vehicle, including a low-speed vehicle or a medium-speed vehicle that is propelled by electric power obtained from overhead trolley wires but not operated on rails. Low-speed vehicle means any four-wheeled electric vehicle, excluding golf carts, whose top speed is greater than 20 miles per hour, but not greater than 25 miles per hour, including neighborhood vehicles. Medium-speed vehicle means any four-wheeled electric or gasoline-powered vehicle, excluding golf carts, whose top speed is greater than 30 miles per hour, but not more than 35 miles per hour. Vehicle means every device upon which any person or property is or may be transported or thrown upon a highway, except the devices used exclusively on stationary rail tracks. Proximate result means a result which in natural and continuous sequence is a product of an act occurring or concurring with another, which had it not happened, the result would not have occurred. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of bodily member, organ, or mental faculty, or broken bone of a child who is 12 years of age or less. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant killed the alleged victim, and two, that the defendant acted recklessly. In the context of this offense, a person acts recklessly when the person is aware of, but consciously disregards, a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The person acts knowingly when the person is aware that his conduct is reasonably certain to cause the death of the alleged victim.
Any person who commits the offense of vehicular assault is guilty of a crime. Do you find the defendant guilty of this offense? The state must prove beyond a reasonable doubt the existence of the following essential elements. One, that the defendant caused a serious bodily injury to the alleged victim by the operation of the motor vehicle. And two, that the serious bodily injury was the proximate result of the driver's intoxication. And three, that the defendant acted recklessly. In the context of this offense, a person acts recklessly with respect to the circumstances or result of his or her conduct when he or she acts with an awareness of conscious disregard of a substantial and unjustifiable risk that the circumstances exist for the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The element of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally with respect to the nature or result of his or her conduct. He or she acts with a conscious objective or desire to engage in the conduct or cause the result. When a person acts knowingly with respect to the nature, the circumstances, or the result of his or her conduct, he or she acts with an awareness of the nature of his or her conduct, that the circumstances exist, or that his or her conduct is reasonably certain to cause the result. If recklessness establishes an element of the offense, the person is unaware of the risk, causes voluntary intoxication. The person's unawareness is immaterial in the prosecution for that offense. Voluntary intoxication means intoxication caused by a substance the person knowingly introduced in the person's body, the tendency of which to cause intoxication was known or ought to have been known. In the context of this offense, motor vehicle means every vehicle that is self-propelling, including low-speed and medium-speed vehicles that execute on electric scooters, motorized bicycles, personal delivery devices, and every vehicle that's propelled by electric power obtained from overhead trolley. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of function of bodily member, organ, or mental faculty, or broken bone of a child who is 12 years old or less. Bodily injury includes a cut, abrasion, bruise, burn, disfigurement, physical pain or temporary illness, or impairment of a function of bodily member, organ, or mental faculty. Proximate result means a result which, in natural and continuous sequence, is the product of an act occurring or concurring with another, which, had it not happened, the result would not have occurred. Intoxication is defined as acting under the influence of an intoxicant. The expression under the influence of an intoxicant covers not only all the well-known and easily recognized conditions and degrees of intoxication, but also any mental or physical condition which is the result of taking an intoxicant in any form, which deprives one of that clearness of mind and control of oneself which one would otherwise possess. In this situation, it would not be necessary that the person be in such a condition that would make him guilty of public drunkenness. The law merely requires that the person be under the influence of an intoxicant. The degree of intoxication must be such that it impairs the driver's ability to safely operate the motor vehicle by depriving the driver of the clearness of mind and control of himself which he would otherwise possess. Evidence from blood or breath alcohol tests that there was, at the time alleged, 0.08% or more by weight of alcohol in the defendant's blood creates an inference that the defendant was under the influence of such intoxicant and that the defendant's ability to drive was impaired. This means that if you find from the proof that the defendant was found by means of a blood test to have 0.08% or more by weight of alcohol in the defendant's blood, you, the jury, are permitted to infer that the defendant was under the influence of such intoxicant, and that the defendant's ability to drive was therefore impaired. However, you are never required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by the evidence in this case warrant any inference, which the law permits you, the jury, to draw from any blood test result. Also, the inference may be rebutted by other evidence and circumstances. It is for the jury to determine, after consideration of all the evidence, whether to make the inference which the law permits, the correctness of such inference, and what weight is to be given to such evidence.
Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant's conduct resulted in the death of the alleged victim. And two, that the defendant acted with criminal negligence. The person acts with criminal negligence, and the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The person acts knowingly when the person is aware that his conduct is reasonably certain to cause the death of the alleged victim. The person acts recklessly when the person is aware of and consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. But the risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find beyond a reasonable doubt that the defendant was criminally negligent, then you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. The defendant's actions need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of a victim or third party, before you can convict the defendant, you must also find beyond a reasonable doubt the after the victim or the third party cause of death was a natural and probable result of the defendant's criminal negligence. Any person who commits the offense of driving under the influence of intoxicant is guilty of a crime. You find the defendant guilty of this offense as included in counts 1, 2, 5, and as charged in count 8. The state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant was driving or was in physical control of an automobile or other moving vehicle. And two, that this act occurred on the public road or highway, on any street or alley, following premises of any shopping center, or premises that is generally frequented by the public at large. And three, that the defendant was under the influence of intoxicant. For you to find the defendant guilty of this offense as charged in count 9, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant was driving or was in physical control of an automobile or motor driven vehicle. And two, that this act occurred on any public road or highway, on any street or alley, on premises of any shopping center, or premises that is generally frequented by the public at large. And three, that the alcohol concentration in the defendant's blood or breath was 0.08% or more. Intoxication is defined as acting under the influence of intoxicant. Expression under the influence of intoxicant covers not only all the well-known and easily recognized conditions and degrees of intoxication, but also any mental or physical condition which is the result of taking an intoxicant in any form, which deprives one of that clearness of mind and control of oneself, which one would otherwise possess. In this situation, it would not be necessary that the person be in such a condition as would make him guilty of public drunkenness. The law merely requires that the person be under the influence of an intoxicant. The degree of intoxication must be such that it impairs the driver's ability to safely operate a motor vehicle by depriving the driver of the clearness of mind and control of himself which he would otherwise possess. If you've heard from the proof, tests were conducted for the purpose of determining the alcohol content. If you have heard from the proof that tests were conducted for the purpose of determining the alcohol content of the defendant's blood. Evidence from the test that there was, at the time alleged, 0.08% or more by weight of alcohol in the defendant's blood creates an inference that the defendant was under the influence of such intoxicant, and that the defendant's ability to drive was impaired. If you find from this proof that the defendant was found by means of a blood test to have 0.08% or more by weight of alcohol in the defendant's blood, you, the jury, are permitted to infer that the defendant was under the influence of such intoxicant, and that the defendant's ability to drive was therefore impaired sufficiently to constitute a violation of the law against driving under the influence of alcohol. However, you are never required to make this inference. it is the exclusive province of the jury to determine whether the facts and circumstances shown by the evidence in this case warrant any inference from which the law permits you, the jury, to draw any blood test result. Also, the inference may be rebutted by other evidence and circumstances. It is for the jury to determine, after consideration of all the evidence, whether to make inference which the law permits, the correctness of such inference, and what weight is to be given to such evidence. In deciding whether or not the defendant was in physical control of an automobile or motor-driven vehicle, you may take into account all the circumstances proven in the trial, including the location of the defendant in relation to the vehicle, the whereabouts of the ignition key, whether the motor was running, the defendant's ability for his intoxication to direct the use or non-use of the vehicle, or the extent to which the vehicle itself is capable of being operated or moved under its own power or otherwise. Or you can convict the defendant. The state must prove the defendant was in physical control of an automobile or motor-driven vehicle beyond a reasonable doubt. Whether or not the circumstances shown in the trial prove that the defendant drove or was in physical control of an automobile or motor-driven vehicle are matters for your determination. Any person who commits an assault upon another is guilty of a crime. If you find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. One, that the defendant caused bodily injury to another, and two, that the defendant acted recklessly. In the context of this offense, the person acts recklessly with respect to the circumstances or result of his or her conduct when he or she acts with unawareness, conscious disregard of a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The element of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally with respect to the nature or result of his or her conduct. He or she acts with a conscious objective or desire to engage in the conduct will cause the result, and the person acts knowingly with respect to the nature, circumstances, or the result of his or her conduct, and he or she acts with an awareness of the nature of his or her conduct, the circumstances exist, or that his or her conduct is reasonably certain to cause the result. If recklessness establishes an element of an offense, and the person is unaware of the risk and cause of voluntary intoxication, the person's unawareness is immaterial in a prosecution for that offense. Voluntary intoxication means intoxication caused by substance that the person knowingly introduced into the person's body. The tendency of which to cause intoxication was known or ought to have been known. Bodily injury includes a cut, abrasion, bruise, burn, disfigurement, physical pain or temporary illness or impairment of the function of bodily member or your mental faculty. Any person who commits the offense of reckless aggravated assault is guilty of a crime. If you found the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. One, that the defendant recklessly caused bodily injury to another, and two, that the act involved the use of a deadly weapon. In the context of this offense, the person acts recklessly with respect to the circumstances or result of his or her conduct, and he or she acts with an awareness and conscious disregard of a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The element of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally with respect to the nature or result of his or her conduct, and he or she acts with a conscious objective or desire to engage in the conduct will cause the result, and a person acts knowingly with respect to the nature, the circumstances, or the result of his or her conduct, and he or she acts with an awareness of the nature of his or her conduct, the circumstances that exist, so that his or her conduct is reasonably certain to cause the result. If recklessness establishes an element of an offense, the person is unaware of the risk because of voluntary intoxication. The person's unawareness is immaterial in the prosecution for that offense. Voluntary intoxication means intoxication caused by a substance that the person knowingly introduced to the person's body. The tendency of which to cause intoxication was known or ought to have been known. Bodily injury includes a cut, abrasion, bruise, burn, disfigurement, and physical pain or temporary illness or impairment of the function of the body member, organ, or mental faculty. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Any person who commits the offense of reckless endangerment is guilty of the crime. You can find the defendant guilty of this offense. The state must prove beyond reasonable doubt the existence of the following essential elements. One, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury. And two, that the defendant acted recklessly. And three, that the offense was committed with a deadly weapon. In the context of this offense, the person acts recklessly with respect to the circumstances or result of his or her conduct when he or she acts with an awareness that conscious disregard of a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that disregard constitutes a gross deviation from standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The element of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally with respect to the nature or result of his or her conduct, and he or she acts with a conscious objective or desire to engage in the conduct cause the result, and a person acts knowingly with respect to the nature, the circumstances, or result of his or her conduct, and he or she acts with an awareness of the nature of his or her conduct, and circumstances that exist, that his or her conduct is reasonably certain to cause the result. If recklessness establishes an element of offense, and the person is unaware of the risk to cause of voluntary intoxication, the person's unawareness is immaterial in the prosecution of that offense. Voluntary intoxication means intoxication caused by a substance that the person knowingly introduced in the person's body, the tendency of which to cause intoxication was known or ought to have been known. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty, or broken bone of a child who is 12 years of age or less. Bodily injury includes a cut, abrasion, bruise, burn, disfigurement, physical pain or temporary illness or impairment of the function of bodily member, organ, or mental faculty. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in a manner of its use or intended use is capable of causing death or serious bodily injury. Any person who commits the offense of reckless endangerment without a deadly weapon is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond reasonable doubt the existence of the following essential elements. One, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury. And two, that the defendant acted recklessly. In the context of this offense, a person acts recklessly with respect to the circumstances or result of his or her conduct. He or she acts with an awareness to a conscious disregard of a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The element of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally with respect to the nature or result of his or her conduct. He or she acts with a conscious objective or desire to engage in the conduct. or cause the result, and a person acts knowingly with respect to the nature, circumstances, or the result of his or her conduct, he or she acts with an awareness of the nature of his or her conduct, the circumstances exist, or that his or her conduct is reasonably certain to cause the result. If recklessness establishes an element of an offense, the person is unaware of the risk because of voluntary intoxication. The person's unawareness is immaterial in the prosecution for that offense. Voluntary intoxication means intoxication caused by a substance that the person knowingly introduced the person's body, the tendency of which to cause intoxication was known or ought to have been known. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty, or broken bone of a child who is 12 years of age or less. Bodily injury includes a cut, abrasion, bruise, burn, disfigurement, physical pain, or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict a defendant, the state must show beyond a reasonable doubt that a person or class of persons was within the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct will place others in imminent danger of death or serious bodily injury. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the charged or incurred offense. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charges you that if from the whole proof in the case you are satisfied beyond a reasonable doubt that the defendant committed the charge or an included offense, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the charge or included offense, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or if you have a reasonable doubt as to whether he has been identified from the whole body of the proof in the case, you should return a verdict of not guilty. Before the defendant can be convicted of any degree of homicide, the state must prove beyond a reasonable doubt that the death of the deceased was approximately caused by the criminal conduct of the defendant. The approximate cause of the death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death, which without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to cause the cause of death. In such a case, each of participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may have also been a proximate cause of the death. However, it is a defense to homicide if the proof shows the death was caused by an independent intervening act or omission of another whose defendant, in the exercise of ordinary care, could not reasonably have anticipated is likely to happen. If, however, in the exercise of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. It's not necessary that the sequence of events for a particular injury be foreseeable. It's only necessary that the death fall within the general field of danger which the defendant should have reasonably anticipated. If some other circumstance caused the victim's death unrelated to the defendant's actions, that would be a defense to homicide, unless the circumstance was a natural result of the defendant's act. If you find that the defendant's acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to his proposition, you must find him not guilty. The defense has raised the issue of defects in the chain of custody and the blood sample taken from the defendant and the blood sample tested by the state for blood alcohol concentration. Every possibility of tampering does not have to be excluded. The circumstances must establish a reasonable assurance of the identity and integrity of the evidence. If, after consideration of all the facts and circumstances, you believe that any defects exist in the chain of custody of this evidence, you may consider that in determining the authenticity of this evidence and what weight to give it. The guilt of the defendant, as well as the facts required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact of issue without inference or presumption. Direct evidence may consist of testimony of persons who has but from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is even better than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important the testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely upon your own common sense and everyday experience. There's no fixed set of rules for judging whether you believe a witness. It may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions? Has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influence that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently. Witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. You may conclude, however, that a witness deliberately lied about something that is important on how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about something, but told the truth about others, you may simply accept the part you think is true and ignore the rest. The testimony of a witness may be discredited or impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect the credibility unless it should plainly appear that some witness has willfully testified falsely. The testimony of a witness may also be impeached by proving that he or she has made a prior inconsistent statement, that is a material statement that he or she made out of court that is at variance with his or her testimony on witness stand. However, the earlier statement draws your attention to the sole purpose of discrediting or casting doubt on the accuracy of the witness's present testimony here at the trial. You may not view the witness's earlier statement as proof that something said in it was true. When the testimony of a witness is impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances on the trial. During the trial, you heard expert testimony. Rules of evidence provide that scientific, technical, or other specialized knowledge might assist the jury in understanding these evidence or determining the fact of issue. A witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe his testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reason, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Court instructs you that while there is evidence of a oral written statement given by the defendant in this case, you may take it into consideration all the other facts and circumstances in the case. All this evidence has been received. It remains your duty to decide if in fact such statement was never made. If you believe the statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement. Rather, should consider all of any statement you believe was made and is true. You are the sole judge of what weight to be given to such statement. If you decide a statement was made, you should consider with all the other evidence to determine the defendant's guilt or innocence. The evidence in this case includes facts to which the parties have stipulated or agreed. Stipulation means simply that the plaintiff and the defendant accept the truth of a particular proposition or fact. Since there is no disagreement, there is no need for evidence apart from stipulation. As such, you may accept the stipulation as evidence in regard that fact is proved. You're not required to do so, however, as you are the sole judge of the facts. The court has charged the jury considering an inference that the jury may make in regard to certain evidence in this case. However, the jury is not required to make this inference. It's the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence or both, whether it exists in the evidence of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut the inference raised, you should consider such explanation along with all the evidence concerned, not only the correctness of the inference, but also the reasonableness of the defendant's explanation. You're not bound to accept either the inference or the defendant's explanation. The state must prove beyond reasonable doubt every element of the offense before the defendant can be found guilty. The defendant has not taken the stand to testify as a witness. We shall place no significance on this fact. The defendant is presumed innocent. The burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. During your deliberations, you must not communicate with or provide any information to anyone about this case by any means outside the jury deliberation. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including but not limited to Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any other social media, to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. During this trial, you have been permitted to take notes for your own use during your deliberations. The notes you may have taken should not be considered to be a transcript of the testimony. As such, once you retire to the jury room, you may refer to your notes, but only to refresh your own memory. You may not read from your notes to your fellow jurors or otherwise inform them of what you have written. The notes may contain errors that may be understood or taken out of context since they can only pertain to part of the testimony, are not an exact account of what was said by a witness. You're free to discuss the testimony of the witnesses with your fellow jurors, but each juror must rely upon his or her own memory as to what a witness said, did, or did not say. Upon the conclusion of your deliberation, the court will collect and destroy all the notes taken by any juror. Some counts of the indictment include, in addition to the charged offense, one or more lesser offenses. These offenses are listed in order from greatest to least. In reaching your verdict on a count of the indictment, you shall first consider the offense charged in the count. If you unanimously find the defendant guilty of the charged offense beyond a reasonable doubt, you shall return a verdict of guilty for the charged offense. If you unanimously find the defendant not guilty of the charged offense, or have a reasonable doubt of the defendant's guilt of the charged offense, you shall then proceed to consider whether or not the defendant is guilty of the next listed offense. You shall not proceed to consider the lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or if you unanimously have a reasonable doubt of the defendant's guilt of the immediately preceding greater offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in the count, you shall return a verdict of not guilty as to that count. The crime charged in each count of presentment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty on one or more or all counts. Your finding as to each count must be stated in your verdict. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so while respecting individual judgment. Each of you must decide this case for yourself. Do so only after an impartial consideration of evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. When you retire to the jury room, you will first select one of your members as foreperson, who will preside over your deliberations and ensure that they are conducted in a business-like way and everyone has a fair chance to be heard. When you have reached a verdict, you will return to this courtroom, and your foreperson will deliver the verdict forms to the court. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. If, however, you find that the state has not proven the defendant's guilty beyond a reasonable doubt, or if you have reasonable doubt as to the defendant's guilty, then you must find him not guilty. You will be provided with forms for all possible verdicts in this case. The jury will complete the forms and your foreperson will sign and date. The verdict forms you will receive read as follows. With respect to count 1 of indictment 317-849, which charges vehicular homicide of Ana Paso Rodriguez by intoxication, we, the jury, found the defendant Randy Vega. Please mark 1 of the following verdicts: guilty of vehicular homicide by intoxication, or guilty of reckless homicide, or guilty of vehicular assault, or guilty of criminally negligent homicide, or guilty of driving under the influence, or guilty of assault, or not guilty. With respect to count 2, indictment 317-849, which charges vehicular homicide of Jonathan Davia by intoxication, we, the jury, found the defendant Randy Vega. Please mark 1 of the following verdicts: guilty of vehicular homicide by intoxication, or guilty of reckless homicide, or guilty of vehicular assault, or guilty of criminally negligent homicide, or guilty of driving under the influence, or guilty of assault, or not guilty. With respect to count 3 of indictment 317-849, which charges vehicular homicide of Ana Paso Rodriguez by reckless conduct, we, the jury, found the defendant Randy Vega. Please mark 1 of the following verdicts: guilty of vehicular homicide by reckless conduct, or guilty of reckless homicide, or guilty of criminally negligent homicide, or guilty of assault, or not guilty. With respect to count 4 of indictment 317849, which charges vehicular homicide with general immediate about reckless conduct, we, the jury, find the defendant Randy Vega, police marked 1 of the following verdicts: guilty of vehicular homicide by reckless conduct, or guilty of reckless homicide, or guilty of criminally negligent homicide, or guilty of assault, or not guilty. With respect to count 5 of indictment 317849, which charges vehicular assault of Octavia Devia Pass, we, the jury, find the defendant Randy Vega, police marked 1 of the following verdicts: guilty of vehicular assault, or guilty of driving under the influence, or guilty of assault, or not guilty. With respect to count 6 of indictment 317849, which charges reckless and aggravated assault of Octavia Devia Pass, we, the jury, find the defendant Randy Vega, police marked 1 of the following verdicts: guilty of reckless and aggravated assault, or guilty of assault, or not guilty. With respect to count 7, indictment 317849, which charges reckless endangerment of the public at large, we, the jury, find the defendant Randy Vega, please mark 1 of the following verdicts: guilty of reckless endangerment, or guilty of reckless endangerment without a deadly weapon, or not guilty. With respect to count 8 of indictment 317849, which charges driving under the influence, we, the jury, find the defendant Randy Vega, please mark 1 of the following verdicts: guilty of driving under the influence, or not guilty. With respect to count 9, indictment 317849, which charges driving under the influence with a blood or breath alcohol concentration of 0.08% or more, we, the jury, find the defendant Randy Vega, please mark 1 of the following verdicts: guilty of driving under the influence, or not guilty. And the last little bit of this, I'll read to you before closing arguments. As you can tell, this is a very significant case to this community. As you can probably tell, there's been a lot of media on this before, during, and after this trial. I'm about to let you go over the weekend for 2 days. You have to make exceptionally sure to take great care to not be exposed to anything about this case. Media, social media, YouTube videos, searching Facebook, Instagram, these things pop up a lot. So for 2 days, you're going to have to take these extraordinary steps because you have taken an oath as a juror in this very important case. And I know you can do it, but I'm emphasizing this is an unusual case since there has been so much media and it's so important, and you're about to go home for 2 days. Okay? So I need you to do that for me the weekend. We're back to our regular schedule on Monday. We'll be here at 9:15. Take that back. Where's the first second? So we're going to do it as we've done earlier in the week. We'll be here at 9:15. We'll try everything ready for you. Start closing arguments right around 9:30 or soon after, and we'll be back to the at that point. Okay? I will see you Monday.